Ready? Exercise number 27, legal matter. Start. This appeal has been filed by the appellant under section 96 of the CPC against the judgment dated December 2019 under bracket impugned judgment for short bracket out, passed in a civil suit being CS number 6115/2016 under bracket suit for short bracket out. This suit was filed by the respondent plaintiff seeking a decree of possession, recovery of arrears of rent, damages and permanent injunction against the appellant defendant in respect of premises being room number 29, third floor of property number 1663-66 Didwani Motor Market, Kashmir Gate, Delhi, ad measuring 180 square feet under bracket is suit property for short bracket out, being the owner of the same. Stop next para. The facts in brief as noted from the impugned judgment, signature not verified digitally, signed by Ashish Kumar Yadav, signing date 23/2/2021, 18:51 hours, plaint. LCR lease agreement are that the respondent plaintiff let out the suit property to the defendant appellant since 2005, and lastly it was extended via the lease agreement dated June 2014 as executed between the parties under bracket lease agreement for short bracket out for a monthly rent of rupees 3744 payable by the defendant. Stop next para. Owing to defaults in payment of rent with effect from May 2014 and the unruly behavior of the appellant defendant on demands made for payment of arrears of rent, the plaintiff served a legal notice on September 2, 2014 terminating the tenancy of the appellant defendant with effect from October 3, 2014, and also calling upon the appellant defendant to pay rent within a period of 15 days. Since the appellant defendant failed to hand over the actual vacant and peaceful possession of the suit property, the respondent plaintiff filed the suit even though the defendant had put in appearance in pursuance of the trial court's summons. He failed to file the written statement, and finally defense was struck off by the order of signature not verified. Thereafter, appellant defendant moved an application under Order 9 Rule 7 read with Section 151 CPC, and with the said application, appellant defendant also filed his written statement. Stop next para. The trial court, by the order dated April 5, 2017, disposed of the application filed by the appellant defendant under Order 9 Rule 7, whereby, in the interest of justice, order dated August 12, 2015, to extent the appellant defendant was proceeded ex parte was set aside subject to payment of costs. The relevant portion of the order dated April 5, 2017 reads as under. Quote next para. By my separate order of the even date pronounced in the open court today, the application under Order 9 Rule 7 read with Section 151 of CPC made on behalf of the defendant is disposed of in terms that the plea of the signature not verified, and thus seeking setting aside of the order whereby his defense was struck off Under Rule 10 of Order 8 of CPC is declined and his plea for condoning the delay in filing the written statement and taking on record the written statement is also declined. Afterwards, pleadings were completed in the applications, and the application under Order 12 Rule 6 filed by the respondent plaintiff was disposed by the impugned judgment against the appellant defendant. The trial court, after recording the stand and contentions of the parties, held that although written statement was not taken on record from the application under Order 12 Rule 6, plaintiff replied to the application under Order 12 Rule 6. Full stop. Thank you very much.